And now I am going to invite Peter McDonald Eggers. He is well known to you all. He's a leviathan of the insurance bar. Any wisdom on insurance that he can give us is gratefully received. And he's going to talk to us today about the court's interpretation of the Insurance Act 2015. Peter, thank you very much.
Well, thank you very much, David, and thank you very much to ARIAS for inviting me to speak today about a topic which, strangely enough, is very dear to my heart, and that is the Insurance Act of 2015. I have to do that. Not sure. Oh, right, sorry. There we are. When the Insurance Act was passed in 2015, there were cries by many, not just lawyers, but in the insurance world in favor of reforms, but also against the reforms which were being introduced. Some thought it was the beginning of an enlightened period. Others thought it was the end of days. And yet others thought it was a recipe for litigation. And the truth is, we still don't know what the answer is. And the reason for that is that the Act entered into force in 2016, except one of the provisions came to force in May of 2017. So that's 9 years ago now. And the first case to hit the court was in 2020. There was another case in 2022. So up to then, only 2 cases had arisen where the court had considered the Act, and to be honest, on points which were the same as the previous law. But in the past 18 months, I think there's been another 6 to 8 cases. So it may be now that we're seeing more cases enter into the fray. So the question is, how has the court interpreted the Insurance Act? Is it in a way which is surprising, or is it in a way which is entirely to be expected? Now, just to remind you, there were 4 major areas of reform introduced by the Act. You can see them on the screen. One is in relation to the duty of fair presentation, pre-contractual disclosure. The second concerned the impact of warranties and other terms of the insurance contract. The third were remedies for fraudulent claims. And the fourth were damages for late payment. Itself a controversial subject. Now, the Law Commission put a great deal of effort into drafting the bill to a large extent. And those provisions that you can see are well thought out. There are, however, 2 provisions which are introduced late in the day at the instance of the Parliamentary Committee. Now, I'm not saying Parliament hasn't got the right to introduce provisions into their own legislation. They do, but it happened at speed. And you can tell from the drafting that those 2 provisions are less considered, less thought out, and I would say more likely to give rise to litigation. And I'll come back to those 2 provisions later. To me, the most successful provision in terms of providing clarity is remedies for fraudulent claims, because it's absolutely clear what the position is, whether you agree with it or not. And therefore, I'm not proposing to discuss it because there are no cases considering it, and I think it's done a marvelous job. Now, it is worth remembering, oops, we'll get this right one day. It is worth remembering that the purpose of the Act was to make the law more insured-friendly and less insurer-friendly. That was the purpose of the Act. And so the first target was the duty of fair presentation. And the real complaint in relation to the duty of fair presentation was remedies. Avoidance was regarded as an unduly harsh remedy for any type of breach, no matter how serious or no matter how inadvertent and how innocent. The law has been largely unaffected by the Act. So there's still a duty of disclosure, unlike, for example, in relation to consumer insurances. There are still exceptions to the duty, which are largely the same, and they have been considered in a number of cases, you can see. The law in relation to misrepresentation is precisely the same. The law in relation to materiality is the same. The law in relation to inducement is at least arguably the same. Some may disagree. And in relation to variations, the law applies to amendments as it does to insurance contracts. So that's all fine. Sorry, my clicker's not working. Is that me or have I done something wrong? I'm sure I pressed the wrong button. That's good. Thank you. Now, what changes therefore have been brought about to the duty of fair presentation by the Act? Well, I've set them out on the screen, but the two major changes are those in bold. And firstly is the scope of the insured's knowledge, which defines this duty of disclosure. And the corresponding part of that, of course, is the scope of the insurer's knowledge, which is an exception to the duty of disclosure. And then the major change is brought about in the realm of remedies. So it's no longer just avoidance. There's a graduated scheme of remedies depending upon different factors. Oh, okay. It's working, I have to go down. Okay, thank you very much. Great. So my proposal is I'm just going to look at a couple of cases which deal with the Insurance Act in the context of duty of fair presentation. The first, I think, is probably the most substantial decision, which is Delos against Allianz, or the win-win. And I'm going to be as neutral about this case as possible because David Walsh, who's I understand is ARIAS' joint head of education, is on the opposite side to me in that case, and we have an appeal coming up in July, and we'll have to see what's said. So I'm going to keep it as neutral as possible. I'm not going to say whether the judge got it right or the judge got it wrong. I'm not appealing. David's appealing. So very simply, what happened was that a ship went to Indonesia. The master essentially parked the ship in Indonesian waters overnight, unbeknown to him, as the judge found, that he was within Indonesian waters. That led to the Indonesian Navy taking control of the ship, arresting the master, prosecuting the master for criminal offense. And overall, what that meant was the ship was there, was not formally released for about 12 months, I think, and it was actually released 18 months later. The claim was for a CTL was presented, and the insurers defended the claim on 4 grounds. One ground was that there was an unfair presentation of the risk, in that the assureds, and I'll call them the owners that's too simplistic, but I'll call them the owners, did not disclose the fact that the single ship company which owned the ship which had been lost had been charged but not convicted of a criminal offense, and it was a drug trafficking offense. And this individual, the offense was not related to these ships, it was related to another ship-owning group altogether. This information was known to the director, but it was not known to the owners. And the question arose whether or not the insurers could avoid the insurance contract by reason of that non-disclosure. Now, the court dismissed each ground of defense, including the fair presentation defense. And as I say, the appeal is to be heard in July. The court held that there was no unfair presentation of the risk under the Insurance Act. And it did so essentially for, essentially for 2 reasons, I think, or it could be 1 reason. The first reason is that the information was not within the knowledge of the owners. And there are 2 aspects to the question of knowledge. One is actual knowledge, and the second is what I call constructive knowledge, what the insured ought to know. Now, as far as actual knowledge is concerned, the new Act lays down a very, I would say, carefully thought out, intricate test as to what counts as actual knowledge of a company. And remember, the owner of the ship in this case was a company, as well as the managers of the ship. And the test for what counts as the actual knowledge of a company includes the knowledge of at least one individual who forms part of the senior management. And you can see in the halfway down the page, the definition of what counts as senior management is that those individuals who play a significant role in the making of decisions about how the insured's activities are to be managed or organized. Now, in this particular case, the director of the SPV, the single ship-owning company, was a Greek lawyer who was still practicing, hadn't been just suspended or struck off or anything like that. the evidence was, and the judge found, that the director had no control, no influence in relation to the deployment of the ship in terms of its operation, its employment, its crewing, made no decisions, was not involved in the insurance of the vessel. Rather, he was there to fulfill a transactional role, an administrative role. So he would sign transactional documents as and when required. But he essentially, according to the judge, served as a vehicle for the execution of decisions made by the ship managers. And in those circumstances, the judge found that the individual director, who was the sole director of the ship-owning company, did not count as a member of the senior management. And therefore, there was no actual knowledge to be attributed to the owners in relation to the charges which have been brought against the director. Now, the second aspect was constructive knowledge. And the insurers alleged that certain inquiries should have been pursued by the owners of the director as to the state of the director's fitness or to act as a nominee director, and whether or not the director knew of any circumstances which might affect the risk. And I won't go into any detail, but it's worth noting that the judge did not consider that the inquiries which had been proposed or be put by the owners to the director were not inquiries which would reasonably expected to be made. In those circumstances, there was no constructive knowledge. But you can see in the second bullet point, the definition of constructive knowledge, which is an insured ought to know what should reasonably have been revealed by a reasonable search of information available to the insured, whether the search is conducted by making inquiries or by any other means. And it goes on to say that the information in question may be held within the insured's organization or anywhere by any other person. Now, just forgetting about the win-win and just looking at that provision, it seems to me that's an incredibly broad provision, potentially. It's broader than the test used under the Marine Insurance Act, which has a restriction built in the ordinary course of business. That's gone. And so in certain circumstances, it may well be that that is a provision which actually widens the scope of disclosure rather than reduces it. The judge also dealt with other aspects, including materiality and inducement. The judge found that the information was material, according to the traditional test, and there was an element of inducement, but not inducement of the sort which the insurers had contended for. Now I'm going to move on from that to the next case, which is Tynefield Care. And that's an interesting case. I think legally less interesting, I have to say. It's not as interesting as the win-win. The win-win is much more interesting because it's dealing with provisions of the Act which are new and change the law. This does consider some of the provisions, but it's much more straightforward. And essentially what happened here was that the claimants, the insureds, operated care homes, and they were insured under 6 policies from 2013 to 2019. Now, as I said, the Insurance Act came into force in 2016. So any contracts of insurance entered into on or after 12th of August 2016 are subject to the Act. And here there was an allegation against the claimants of a non-disclosure, which I'll explain in a second. But what's interesting, therefore, that 3 of the policies were not subject to the Insurance Act, but 3 of the policies were. So it was almost like an exam question. It was a wonderful opportunity for the court to review the law as it was and as it is. Now, what happened in this particular case? An individual, Mr. K, had been a shadow and a de facto director for the period up to 2016, and then a de jure director, a properly appointed director thereafter. Now, the information which gave rise to the non-disclosure argument and defense was that Mr. K had previously been a director of another company which had operated a fashion business, but which went into administration in 2006. And that's the information which the insurers say ought to have been disclosed. They ought to have disclosed the fact that the shadow director and the insolvency history of Mr. K, and there was a question asked in the proposal form as to the details of you or any other director or partner. Now, as far as the proposal form question was concerned, the court held that that did not extend to the role of any shadow or de facto directors. It was de jure directors. There was also a provision in the policy dealing with cessor of insurance or the termination of the insurance if a director is declared bankrupt or insolvent. Now, as I say, the court addressed a number of issues, and as regards the earlier non-insurance act policies, held that there was a failure to disclose the shadow directorships and the insolvency history, and it was a material circumstance, and that was a breach, therefore, of the duty of the utmost good faith, which was set out in Section 18 of the Marine Insurance Act. Of course, the Marine Insurance Act doesn't apply to this non-marine insurance, but that was declared to be the common law. And in this respect, it followed the decision of Mr. Percy KC, who was sitting as a judge in Berkshire Assets against AXA, where the history or there was allegations made against the director was regarded as a material fact to be disclosed. The court also considered whether the proposal for question was a waiver disclosure and said it wasn't. And that there was a very recent decision, actually, of the commercial court in Clarendon against Aviva, where a similar argument was pursued. And as regards the 2016 to 19 provisions of policies, the court came to the same conclusion. And it's not surprising why, because the court was applying those provisions of the Insurance Act, which basically left the law as it was intact. So one would be very surprised to see that a different result would arise. So I'm going to move on, go past the conditions and look at the second aspect of change brought about by the Insurance Act of 2015, and that's concerning warranties and other terms. Now, there are three sections in the Insurance Act which deal with warranties and other terms: sections 9, 10, and 11. Now, section 9 is a provision which basically abolishes basis clauses. A basis clause is a clause either in the proposal form or in the policy whose effect is to render any representation in the proposal form, or sometimes even wider, any information provided to the insurer as warranted to be true. So you may have a proposal form asking all sorts of questions, all sorts of answers given, and at the end, it's agreed that the answers given form the basis of the insurance contract. And for 100 years, the courts have interpreted that to mean that the insured is warranting the truth of what is said, so that if anything is false, irrespective of its materiality, irrespective of whether or not it induces the insurer, the result is to discharge the insurers from the date of breach, which would be before the date of inception, so that basically the whole contract disappears. Now, this provision was considered in an important decision, Scott Beef against DNS Storage, which went to the Court of Appeal and was heard, which was where judgment was given this year. Now, the first instance decision is a decision of a judge, as one might expect, and if one reads it, one can see that the judge made some errors in classifying what the relevant terms were. And I'm going to come back in a second to Scott Beef, but what the judge held in that particular case is that a particular provision, which is quoted on the screen, which is the assured makes a full declaration of all current trading conditions at inception of the policy period, to be not to be a warranty because of Section 9. Now, in my view, Section 9 doesn't even apply to that for a number of reasons, and partly for reasons given by the Court of Appeal. But one of the important reasons is the basis clauses, at least in my view, which are abolished, are the indiscriminate rendering of pre-contractual representations into a warranty. What the explanatory notes published by the Treasury in company with the Act say, there is nothing wrong with having a specific representation of fact rendered as a warranty. And the judge wasn't taken to that and therefore didn't consider it. The other, Section 9 is also considered in Tynefield very briefly, which is the case I've just referred to. Now, that's Section 9, and it does an important job. But Sections 10 and 11 are really the working aspects of the Act when it comes to warranties and other terms. Section 10 applies only to warranties, not to any other terms. So you have to have something which is regarded as a promissory warranty, at least as defined by Section 33 of the Marine Insurance Act. And that definition remains even after the Insurance Act of 2015. Now, where the law changes is that previously, if you had a warranty and there was a breach, the insurers were discharged from liability forever after, even if the breach of warranty was remedied. Now, under Section 10, the insurers are discharged automatically from the date of breach, but if the breach of warranty is remedied, then the cover reinstates. So it becomes what's sometimes called a suspensive warranty or a descriptive warranty. And this was considered actually by Sir Jeremy Cook when he was sitting in Singapore in PT Adidaya against First Capital. So that's an important change. The real question, the uncertainty, which hasn't yet been considered by the courts, is what does remedying the breach of warranty mean? And there are two definitions, where essentially the warranty requires something to be done or not done, etc., by an ascertainable time. So, for example, having a survey undertaken within 30 days of the inception of the policy, the breach will be remedied if the risk to which the warranty relates later becomes essentially the same as that originally contemplated. So if you have a survey done 40 days after inception rather than 30 days, that probably will reinstate the cover. But for any other warranty, the breach of warranty will be remedied when the insured ceases to be in breach of warranty. Now, that's all fine. The uncertain question is, how does that impact existing fact warranty? So if I give a warranty, essentially, that there are no past claims during the last 5 years, can that ever be remedied? So that's the open question. Section 10(3) sets out defences to a breach of warranty allegation, which remain exactly the same as the Marine Insurance Act test. And then we get Section 11. Now, I said to you before, when the bill was going through Parliament, there were two provisions which were ill thought out. This is one of them. It was ill thought out because it was it was regarded as too controversial by the Law Commission to introduce at that time. And therefore, the Law Commission decided not to include in the bill. But the Parliamentary Committee, as is their right, decided, no, we think this is a really good idea. So we want something along these lines to deal with it. And this is what we are left with. Now, what's on the screen is not the wording of this section. It's my interpretation of the section, which I think is right. But I think it's going to be a challenge to work out what it means in every case. And essentially, what this means is where the insurer seeks to rely upon a breach of a term of the insurance contract, whether a warranty or a condition precedent or anything else, as a defense to a claim under the policy, whether to extinguish the claim altogether or even to reduce it, then the insurer is not entitled to rely upon that term if three conditions are satisfied. The first is the contractual term must not be a term which defines the risk as a whole. So there's a debate as to whether that would or would not encapsulate all exclusions. I mean, to me, I think it would, if an exclusion would not fall within the scope of Section 11, because I think it does define the risk as a whole, but I think some people disagree with that. The second is that compliance with the term would tend to reduce the risk of loss of a particular kind at a particular location or at a particular time. And so, for example, if you've got a warranty requiring repairs recommended by a surveyor to be undertaken, that would tend to reduce the risk of loss at some point of some kind. But if you've got a premium requiring the payment of, a warranty requiring the payment of a premium within 30 days, it's very hard to see how that would reduce the risk of loss. The third requirement is probably the most important, is the assured must be able to prove that non-compliance, that's the breach which occurred with the term, could not have increased the risk of loss which actually occurred in the circumstances in which it occurred. So that doesn't mean, it's not necessarily a strict causation defense, but the insured has to show it would have actually not increased the risk at all, which I think is a tall order. And this provision has been considered in other cases. Now, the first case I want to refer to is Lonham against Scotby. This is an important case because this is where the Court of Appeal had cause to consider the decision made by the judge, where I've already referred you to, where the judge did fall into error, and the Court of Appeal so found. And in this particular case, what had happened was the insured and the claimant had entered into contract whereby the insured would store and freeze the claimant's meat, which was used for consumption. And it was held and found that the meat was actually unfit for human consumption or animal consumption. Now, the insurer was wound up, therefore the claimant brought a direct claim against the insurer under the 2010 Act, which interestingly enough only came into force in August 2016 as well. The court had previously found that the contract between the claimant and the insured did not incorporate the standard industry terms, the FSDF terms. So the issue between the claimant and the insurer, this is a claim under the 2010 Act, was whether the insured had any right to indemnity from the insurer under the policy, having regard to the impact of the Act. Now, the focus of the court's consideration was the duty of the assured clause. And I've already taken to point one, which is the assured makes a full declaration of all current trading conditions at inception of the policy period. And the second is that the assured will trade under those declared terms. And the third is the assured shall take all reasonable steps to ensure that those terms are incorporated into their contracts. There was also a provision which said that the effect of a breach of a condition precedent is that underwriters are entitled to avoid the claim in its entirety, which actually alters the normal impact of a breach of a condition precedent. There we are. Now, as far as Lim 1 was concerned, which was a condition precedent, the assured makes a full declaration of all current trading conditions at inception. There had been non-compliance because the insured had not declared to the insurer that the contract with the claimant was not on the relevant terms. And therefore, whereas in fact, the insured had declared to the insurer that they were on those terms. Now, the judge held at first instance that this was a representation and therefore a misrepresentation. Remember, this is a condition precedent. The assured makes a full declaration of all trading conditions at inception. So the judge was not considering the actual, what was declared, was merely considering the impact of the condition precedent. And therefore, this representation could not become a warranty by virtue of Section 9. And the second aspect was Lim 3, which was the condition precedent, that the assured shall take all reasonable and practical steps to ensure that their trading conditions are incorporated in all contracts entered into by the assured. Non-compliance of this term existed because the contract between the claimant and the insured was not on the relevant terms. And the judge held a number of things and essentially said that the Lim 3 could be breached even if the FSDF terms were in fact incorporated, which is a very strange thing to say, I think. But moreover, it wasn't limited to new contracts and relationships, they extended to existing ones, and it required the assured to take reasonable steps to incorporate their trading conditions into the existing contracts. Then held, she considered that Lim 3 was to be considered in the context of a duty of fair presentation. Remember, this is a requirement to take reasonable steps to ensure that the relevant contracts include these particular terms. Lim 3 put the insured in a worse position, and therefore the transparency requirements of the Insurance Act, which requires fair notice to the insured, were not satisfied, and therefore the insurer could not rely upon this provision. Now, the Court of Appeal overturned that judgment, and essentially, in a very, I mean, it's quite a long judgment, most of which is actually concerned with setting out what the Act does and says, but quite concisely, the court says that the judge erred in treating all of the relevant provisions in the duty of assured clause as representations or warranties. The court said they were not pre-contractual representations, but future warranties, and they were unaffected by Section 3 of the Act, which relates to duty of fair presentation, but was instead governed by Sections 9 to 11 of the Act. And therefore, those provisions did not disable the reliance by the insurer on those warranties as a defense to the claim. The court also held that the clause specifying the remedy of avoidance did not alter that position at all. Didn't actually comment on the ability of that provision there. So that's Scott beef. The law was, I think, actually in some uncertainty as a result of the first instance decision, but the Court of Appeal has regularized position in that recent decision. Now, Mock Petro against Argo. I think, David, you were in this one. Yeah. Mock Petro was, again, I think the Insurance Act was considered towards the end. I'm not sure it occupied a dominant part of the proceedings, but it was still considered by the court. And it was essentially, it was a question of whether or not there was cargo damage and I've put the facts on the page, but you will see that essentially there was gasoline was loaded on board a vessel. It comprised various different aspects which were loaded from different shoreside tanks, and they were then mixed on board the vessel to create this new product. And it was certified as complying with the relevant contractual specifications, and it was then unsold. Now, the vessel arrived at Hodeida. The cargo was found to be off specification, then had to be diverted to Fujairah, where again the cargo was tested and again found to be off specification, and it was ultimately sold. And the relevant tests showed that the cargo blended in its actual proportions would always have had a phase separation temperature substantially in excess of what was required, meaning it was always going to be off specification. Now, it was insured under an all-risk marine policy, incorporating the ICCA term, so all-risk cover. And the cover was short tank to short tank, and as the insurer reinsured the cargo with the defendant on back-to-back terms. A declaration was made in relation to the cargo with an agreed value of $7 million, and a claim was made for an indemnity. Now, the insurer argued that the cargo could never have been on specification as certified at the load port, but in fact was off specification and therefore unmarketable, irrespective of any subsequent water contamination. And therefore, the court in those circumstances accepted the argument and said that the insured could not discharge the burden of proof that the cargo was in the condition as certified at the load port. And it was not satisfied that the load port certificates accurately set out the quality of the cargo as it existed. And there was a separate argument as to whether actually the blending of the cargo was itself a fortuitous event, which the court rejected. Now, where it becomes relevant for the Insurance Act purposes is the survey warranty in the policy, which essentially required a survey to be carried out at the load port, including a certification of the shore tanks and the pipelines between the vessel and the shore tanks. And the court held that this warranty was breached, not as regards the inspection itself, but as regards the certification, because the inspectorate, who were the surveyors, did not provide any certificate relating to the shorelines until March of 2023. And the policy further provided that failure to comply with the warranty will, in normal circumstances, void this policy. Now, as far as this provision was concerned, the court held this was not an alteration of, or a legally binding term which altered the position under the Insurance Act. It was nothing more than a warning, and therefore it had no impact. The court also considered the impact of Section 11 and said it did not apply because it could not be proved that non-compliance with the warranty could not have increased the risk of loss which actually incurred, which seems to me to be right. So that's warranties in other terms. We've got three provisions, sections 9, 10, 11. There are massive questions which arise in relation to all three questions which have not yet been grappled with by the court. Then the final topic for discussion is section 13A. Now this, I said to you, there are two provisions which were, I think, ill-considered by Parliament when drafting these statutory provisions. Section 13A was not intended to be a part of the original bill. That's why it was brought in by way of an amendment to the Act after it was passed. I find this very interesting. You probably don't, but I actually looked into the history of the passage of the Act and who gave evidence about what they said. Now, the two lawyers who gave evidence before the Parliamentary Committee happened to be Lord Justice Longmore and Lord Mance. What's interesting that they were both asked this question almost, I think, off the cuff. They weren't expecting to deal with it. They were asked by the Parliamentary Committee about the need for Section 13A. And before I tell you what they said, Section 13A essentially, I mean, it's on the screen, but the purpose of it is to get over the old common law rule that an insured who's not paid its insurance, has been paid its insurance indemnity within a reasonable period or any time, is not entitled to claim consequential losses as damages over and above the insurance indemnity. So the rule is you can't get damages for late payment of damages, and an insurance indemnity are damages. So Section 13A was brought in to deal with that issue. Now, Lord Justice Longmore and Lord Mance were asked about the desirability of this as not so much the drafting as the desirability of this additional entitlement to damages over and above the indemnity as a desirable thing. And as I say, I think they were asked off the cuff, so they weren't expecting it. Lord Justice Longmore said he would like to think about it and would write a letter to the committee, which no one's ever seen, at least to my knowledge. It's not, and I mean, I've not seen it in any public record. Lord Mance, actually, who was very critical of the legal position at the common law over a number of years, actually thought it was not a good idea. And I'll put it this way: he certainly did not wholeheartedly say this should be done. So, notwithstanding whatever Lord Justice Longmore may or may not have said, and notwithstanding what Lord Mance did say, nonetheless, the Parliamentary Committee introduced it. Now, the problem with it, I mean, it's been applied in the spirit it's intended to be applied. The problem with it, it doesn't actually fit the previous law. The previous law was you couldn't even get damages for the late payment of insurance indemnity, even if there was an express term saying you have to pay this within a reasonable time, or within 30 days or 60 days. That didn't change anything. All the Act does is to introduce an implied term that the indemnity has to be paid within a reasonable time. It says nothing more. So if an express term is not going to change the common law, it's very unlikely that an implied term is going to change the common law. But that's not the purpose of the Act. It's clear that what motivated the Act was to allow an insured to claim damages. And I think it'd be a very brave advocate to say otherwise. And I've argued two cases, and I haven't said otherwise yet, anyway. Now, as far as a reasonable time is concerned, that's a question of fact, and you can see the factors which contribute to that assessment. Now, as I say, there are two cases which have considered Section 13A. The first was Quadra against Excel, which is a warehouse fraud. And in that particular case, what the court was considering, firstly, what was a reasonable time in a complex warehouse fraud insurance claim. And the court said 12 months was a reasonable time in which to pay the insurance indemnity because of the investigations which would have to be carried out and because of the complexity of the issue. The second issue was, even if the insurers were not entitled to defend the claim, so they were obliged to pay the insurance indemnity, which the judge ultimately found they were, the question arose whether damages should be payable on top of the insurance indemnity. Now, Section 13A4 has a defense which basically says if the insurer have reasonable grounds for disputing the claim, that will operate as a defense to any claim for breach of the implied term by way of, in terms of a claim for damages. And in this case, the court held that even though the insurer's defense did not succeed, there were reasonable grounds for contesting the claim. And therefore, the breach of the implied term claim did not get off the ground. And I think that's what was intended by the Act, but it wasn't absolutely clear because of the drafting. But that's what the judge found. And I think no one would dispute that nowadays. Oops. No, I missed something. Oh, yes. The second case, which did consider it, was the win-win, where a claim was made by the insured again for a breach of Section 13A implied term, but the judge dismissed that as well. But the judge did raise the question, is an entitlement to damages limited to conduct prior to the issue of proceedings or not? And that gives rise to very interesting questions, particularly in marine insurance, where often proceedings can be issued immediately after a casualty for a number of tactical reasons. But that the judge did, I don't think, resolve that question on that particular occasion. But in that case, the claim was denied as well. So we've got two cases considering Section 13A, and in neither case has a claim been successful. We'll have to see whether or not it will be relied upon in the future. Now, that's all I want to say about the Insurance Act. There have been a number of cases, I think 6 or 8 in the last 18 months. I think 2 are very significant. One is the win-win, which is, as I say, going to appeal in July, and the other is the Scott Beef decision, which does clarify the operation of the Act to some extent anyway. The others, I think, are less controversial, but and the only other decision which I think is of great assistance is the Quadra decision, which explains the impact of Section 13A. So with that, you will see that I've I don't know if you've enjoyed it, but I thoroughly enjoy giving this talk. And as I say, it's dear to my heart, and I'm interested to see how it will develop in the future. But I'm here to answer any questions you might have. So let me know.
Peter, I think you said early on in the talk that the Act had clarified the insured's knowledge for the purpose of duty of fair presentation, particularly corporate knowledge, and the fact that said to include either senior management or the people who place the insurance.
Yes.
And the Act, I think, expressly says that the Hampshire land principle subsists, so that agents defrauding their principals don't have their knowledge attributed to the
Correct.
principal. But do you have a view on what's happened to what was called the Arab Bank extension to the Hampshire land principle, namely the idea that if the director of the policyholder is defrauding third parties, that the policyholder itself is the secondary victim, and therefore
no, there's no. I mean, well, there are certainly other cases dealing with Hampshire land outside the insurance area, which I think reveal that this notion of secondary victims is a tenuous one, because there are a number of academic articles which address this. Because if it is allowed to its full extent, it completely undermines the notion of vicarious liability for the fraud of an agent or an employee. But nothing which is, I think, resolved the secondary victim analysis at all. To me, I'm a bit of a purist. I think Hampshire land really it does apply where the objective of the agent or the employee is to defraud its principal or its employer, not anyone else.
Peter, just going back to Scott Beef, which is a really interesting decision. I think as a practitioner, when you sort of read the first instance decision, you sort of a little bit of rolling of eyes, but you then sort of thought, well, if the spirit of the Act is to try to encourage fairness and achieve some more of a balance in terms of the insured's favour, you sort of could see where the front line judge was going. Although I agree with you, the reasoning is difficult to follow. But when you look at the Court of Appeal decision, do you think the Court of Appeal has gone too far? And do you think we might have a decision that tries to sort of marry the two later? Or do you think the Court of Appeal are right?
Well, I certainly think the Court of Appeal are right. I don't think it's gone too far. I think that the essence of the Court of Appeal's decision is really to classify what the duty of the assured clause was and was not. So it was basically saying it was a warranty or a contractual term of some sort, but it was not a pre-contractual representation. And I think that's absolutely right. So I don't think it's going too far. I think it's just stating the obvious. If you look at I actually don't think they say very much about the Act in terms of what they think it means or how it operates. It's a very what's the word? Clinical approach. And that could be part, and forgive me, because I'm not obviously disparaging the work of the Court of Appeal, but this was a TCC decision, and it went on appeal, and it had two TCC Lord Justices on the appeal court. There were no commercial court justices Lord Justices in the Court of Appeal. So we didn't have the benefit of a commercial judge at first instance or of a commercial judge in the Court of Appeal because it was TCC. So I think you may have seen a different approach at both levels had there been more of a commercially influenced judge. Now, that's not to say TCC judges don't know their insurance law. They do, because they do to get a lot of insurance disputes. But I think they may see it in a different angle, a different light than commercial court practitioners do. So.
Or just sort of one final observation again from sort of the coalface. When the Act came in, we were expecting an awful lot of activity in relation to the duty of fair presentation. But actually what we found when you're looking at it is that the results probably are fair. You're speaking to underwriters and you're having discussions with them about what they might have done, what they wouldn't have done. And actually you sort of do reach a resolution. And I think the broking community have played a massive role here, because they've sort of said, well, this really is about fairness. And you can sort of see where the brokers are sort of saying, well, we didn't know this point. You sort of see where the happy medium is. So it may be that one of the reasons why we haven't seen this sort of deluge of cases about fair presentation is that ultimately the right result gets reached. Well, that may be for the first 10 years, whether that continues.
Yeah, I'm not sure. I mean, it's interesting. If you look at the win-win, for example, that was a 2019, I think, event. So that was a case which took 5 years to reach judgment. So if you look at the entry into force of an act of 2016 and you add 5 years, you get 2021. Now, it's the trickle of cases is a bit slower. So I suspect you'll get more and more cases going forward. But you may be right. I think what the Act does allow is for particularly in terms of remedies, because it's no longer avoidance or nothing, there are intermediate remedies, then there's more for the parties, the insurers and the insurers, to discuss and negotiate with than there had been in the past. So I think that's right. But when the Act came into play, I mean, I was sort of advocating for a much more laissez-faire approach when it comes to remedies, allowing the court to distribute the remedies as it saw fit, rather than being avoidance or only in certain circumstances, or rewriting the contract in certain circumstances, or reducing the claim in certain circumstances, because that fit within the Misrepresentation Act, which gives a discretion to the court to substitute avoidance with the order for damages. But no one has really considered what the impact of the Misrepresentation Act is. So that's still another area of dispute. So I think what you say is probably right, in sense there's a question of fairness involved. But I still think, for example, the duty of disclosure is broadened rather than shrunk under the 2015 Act. I suspect we'll see a greater, not a trickle, but maybe a rivulet of cases coming forward.
Yeah, just one thought. Do you see a differentiation between direct and reinsurance? The fact that reinsurance obviously is a broker's specific, is honourable engagement, and there's an expectation of knowledge and understanding of the risk being presented and the risk being underwritten between two sophisticated parties. So do you see that there may be two different levels of expectation, shall we say?
Yeah, I think so. I mean, reinsurance creates all sorts of difficulties, but you're right. You've got, in the general case, you've got a reinsured and a reinsurer who are both familiar with the insurance business, the way that business is done, and they're sophisticated, and they should or should not know various things. There still are disputes now which involve breaches of the duty of fair presentation in the reinsurance context. But of course, there are many other reinsurances which are just where the reinsurer is just a captive or the front, which do give rise to the same old problems, particularly where you've got a presentation by the original insured directly to the reinsurer, and then you get the reinsured being slotted in afterwards. So that gives rise to the same old problems as before. But the important thing is the Insurance Act does apply to reinsurance as well.
Peter, we're practitioners here, I guess most of the time are concerned with the larger commercial transactions and reinsurance as opposed to insurance. But as an expert, I've received a number of appointments over recent years where the issue of representation or misrepresentation becomes clouded by the fact that for personal and small commercial business, often now those transactions occur online, and there's a prescriptive screen which asks certain questions, and it may not be comprehensive enough to cover all of the activities of an insured or all of the history of an insured, and the broker is remote. So although the broker is supposed to know his client, he's just a cog in the transaction. Do you see any differential, perhaps going back to Steve's question, any differential representation issues are being applied in those circumstances where the transactions are done online and we're dealing with personal lines and small commercial?
Well, I think in two respects, Pat. I mean, obviously having online transactions is actually a benefit to the lawyers because you're having documentary records of what is said and what is not said, which may not have existed previously. So if it was done as an oral presentation. But you're right, some of these online questionnaires, if you like, or forms do ask broad questions, and they sort of encourage pithy answers, which may underplay or overplay the significance of what's being said. But so I don't know if it's had an impact yet. I would hope that anyone, whether it's a judge or an arbitrator considering it, would think, well, would understand the limits of the forum in which these questions are being asked and answered, and would take that into account. And in a way, that's the way Pan-Atlantic and Pinetop was considered when it was heard, and that was obviously before online presentations. So at the moment, I'm not sure I've seen a marked difference, but I can certainly see the dangers, if you like, or depending on point of view, the opportunities of online presentations.
Yeah, I mean, one in particular that I was involved in, the insured didn't fit neatly into the profession description, which was online, and the broker had reason, I would say, to have had a discussion with that insured about precisely the activities that were taken on, and did not do so. And so the claim the claim was avoided by the insurer because the activity was not within its appetite for that type of risk. And that's not the only occasion that I've seen.
Right. Well, I've been interested to see those sorts of cases, I have to say.
Well, Peter, thank you very much indeed for that tour de force and being so brave as to state the questions. So thank you very much.